Today we're going to look at the opposition to the registration of a trademark pursuant to the non-use ground found in Section 59 of the Trademarks Act. Section 59 states that registration of a trademark may be opposed on the grounds that the applicant does not intend to use or authorize the use of the trademark in Australia or to assign it to a body corporate in relation to the goods or services specified in their application. The applicant is the person who is named in the application at the time of the proceeding, and any interested third party may oppose registration by filing a notice of opposition. The onus of proof will be on the opponent to demonstrate that the applicant lacks an intention to use the trademark in Australia. If they establish this, the onus will shift to the applicant to show that they in fact did have the requisite intention. Intention is critical to the operation of this section. The applicant must have an intention to use the mark at the date of filing for the mark. This doesn't mean they have to have used it yet, they just have to show that they have an intention to use it. That intention must be a real and definite one, and it must be in good faith. There is also a presumption that weighs in favor of the applicant, which states that by applying for the trademark, they demonstrate an intention to use the trademark. In the case of Food Channel Network Proprietary Limited and Television Food Network GP, the appellant Food Channel was operated by Mr. Lawrence, and they applied for a trademark which featured a TV with a chili and banana as the antenna and Food Channel across the screen. Television Food Network had several similar marks registered for Food Network and contested the registration on several grounds, including Section 59. The court held that Television Food had not demonstrated that Food Channel lacked the requisite intention, and this was because that there was evidence that showed that Food Channel had used the trademark on recipes that they had provided to butchers, and therefore they were using it as a badge of origin, showing an intention to use the trademark. In a case where Section 59 did succeed was Danjag and Resource Capital Australia. Resource Capital Australia applied to register the trademark James Bondy, and Danjag, who owned the trademark James Bond, opposed registration. Resource Capital had a history of applying for deceptively similar trademarks and also cyber squatting on domain names. The court drew adverse inferences from Resource Capital's history and concluded that they did not have an intention to use the trademark. Some other examples come from Phone Directories Company Australia and Suyen Corporation, and both of these cases basically say that the intention does not need to be acted upon immediately. Failure to use the trademark immediately does not show a lack of intention. So in summary, any interested third party can oppose registration for non-use. A person who applies for a trademark needs to have an intention to use the trademark, and that intention is assessed at the date of the application. By applying for registration, there is a presumption in favor of the applicant, and clearly, from the Food Channel case, it is difficult to demonstrate a lack of intention. Finally, that intention does not need to be acted upon immediately.